I got my second shot on Saturday. I had no adverse reactions, thankfully. Not everyone's so fortunate. I had several students email me saying they weren't feeling well because of the shot, so maybe I'm an outlier. But just a little bit of soreness in the arm, just a little bit. In fact, I think it's even less soreness than I had from the first shot. So pretty thankful. I woke up, Sunday morning. Oh wow, I feel good. I was kind of nervous, but nothing happened. It's often important to sort of stop and reflect what we're doing here. I started teaching at South Texas in 2012. When most of you were in middle school, I guess. And if you had told me that at some point in my career there would be some sort of global pandemic where we'd all be wearing masks and wouldn't leave our houses, and law school would shift to completely online, in the span of days, I wouldn't have believed it. That's just something that was beyond my realm of thinking. Like, you think of a pandemic, these zombie movies, right? Where everyone's sort of like airborne disease and people are just dying. Like I Am Legend, where, Dawn of the Dead, right? Where everyone just sort of died. That's what the pandemic was. And, here we are. We are now basically in the second year of this world. Now, you guys came in as 1Ls. You never even had a normal semester. And it's just truly something to just pause and think of what we're doing. Sitting here looking at 35 faces and a handful of you in a classroom. And here we are. So we're almost done. We have today and a class on Wednesday, and that's our last substantive class. Next week on Monday, I'm doing an in-class review. I'll tell you which one I want you to do. It's probably going to be the spring 2020 exam. I'm not sure yet, but probably spring 2020. Either question 1 or question 2. I haven't decided yet. And you'll do that in class, and then I'll go over it the following day or the following Wednesday. And then we're done. That will be the 28th, and then we're done. God willing, in the fall, we have in-person classes. You'll get to see me at some point, in real life. I promise I don't bite. But yeah, we'll be back soon. But I want you to just remember and just sort of reflect of what you went through. You were sort of this noble experiment of, can you do 1L online? And maybe you think it didn't work, but all things considered, this has been a fairly smooth year. It's something that I didn't think was possible, that we did pretty well. And I give a lot of, credit to my colleagues and, the dean and everyone else, but it's just the amount of work that went into making this happen is not simple. You kind of just show up, but there was a ridiculous amount of meetings we had over the summer and planning and prepping. It's just painful. Anyway, someone asked, I got the second dose of Pfizer, and yeah, just a little soreness. I feel guilty even saying it, but I didn't have the sort of fevers and the chills. But I'm glad some of you are getting it, and hopefully you are 2 weeks in and ready to roll. Anything else? All right. So let's start our lesson for today. We are continuing our discussion of landlord-tenant law. And in our last class, we were talking about what happens when the landlord messes up. For example, the landlord does make the premise available right away, or there's a holdover problem, right? Today's class is different. Today's class is where the tenant is at fault. Specifically, the tenant breaches a term of the lease, or the tenant fails to pay rent at all and tries to get out of the lease. What you'll find is that the topic of landlord-tenant law is unique in property. It's very modern, and almost every jurisdiction has adopted modern rules in some regard involving landlord-tenant law. Common law rules are still filed for actually, selling a fee simple. But for whatever reason, leases are treated differently. All right, so let's just do a poll question to start. Guess thinking about this issue. This will be question number 1. Okay. And the question begins like this. L leases Blackacre to T. T then assigns his interest in Blackacre to S. S fails to pay rent and is judgment proof. L can sue T for the rent S failed to pay. True or false? Okay. All right. Who's up next? Okay, Jessica. Go ahead. What's your answer here?
I said false.
Okay. Why'd you say false?
Because T, as the assignor, gave his full interest to S, and there's no privity or relationship or whatever between S and T anymore.
Very good. Very good.
So, yeah.
Excellent. Okay, the answer is false. Keep in mind, everyone, with an assignment, there is no relationship anymore between the landlord and the tenant. The relationship will only exist between the landlord and the sublessee, in this case, S. That's why S is like sublessee, right? The tenant is completely out of the picture. Okay. Are any questions on that one? They're fairly straightforward. All right, then let's start our first topic for today and discuss the tenant who defaults. Now, when you hear the word default, you probably think of like a default font, right? In Word, that's how people today think of default, but historically default had a different meaning. Default means you didn't fulfill your obligation. You didn't pay a loan. You didn't pay rent. You breached, right? Default is more or less a breach, if you want to think of an easy way of describing it. When you default on a contract or a lease, you've breached it. Okay? So what happens when there's a breach of a lease? The common law rule is that the landlord can engage in what's called self-help. Self-help. Alexandria, are you here?
Yes, I'm here.
Help us out. What is self-help?
It kind of means you take the matters into your own hands and you evict the tenant yourself, either by locking them out or removing them from the property.
Okay, what do you mean take the matter into your own hands? What does that realistically mean? You throw them, pick them up and throw them?
The modern approach is to employ the help of the judicial process.
Oh, no, I know that's modern. Let's just do the old school first, right? What does it mean if there's self-help and the person's still living there? What do you have to actually do?
Make them leave.
Okay, how do you make them leave with self-help? You're too nice.
You can do it through formal notification of eviction or changing the
Okay, let's just Bushman. What does it actually mean to change the locks on someone? What does it actually realistically mean? What happens to all their stuff?
It's left behind.
And what do you do with it if you're the landlord?
Throw it away.
No, you sell it to satisfy the debt. Do you give them a chance to buy it back?
No.
You could, but you don't have to. See, you're too nice to Alexandria. That's the problem, right? You would never think of doing that. Well, common law was a very harsh remedy. Self-help meant exactly that. If the landlord determines that there's a breach, there's a default, the landlord would then take matters into his own hand. And realistically, what that meant is he would change the locks. And after he changed the locks, in theory, he could sell the person's stuff. He could also put it in a box and say, "Go take it away," but he'll lock the person out, and then he can rent the apartment or the unit to someone else. right? Now, Grant, you here?
I'm here.
Grant, what were some of the risks of this common law method of self-help? Well, why was it sort of risky?
Well, the primary risk is that it's obviously going to lead to a dispute, and that might erupt into a breach of the peace.
Yeah, well, why might there be a dispute, Grant?
Because people don't want to be evicted.
Yeah, no kidding, right? People don't want to be evicted, but what specifically about this type of self-help might happen? What might occur if the landlord decides for himself there's a breach?
Not sure what you're driving towards.
Let me put it this way. When the landlord says there's a breach, is there always a breach?
No, it's definitely a judicial dispute, a legitimate dispute.
Why might there be a dispute over whether there's a breach? Isn't it simple, straightforward?
No, it's a matter of fact, and landlord's facts might be landlord's allegations might be different from the tenant's facts.
Has a landlord ever been known to lie about maybe or exaggerate a potential breach?
I really don't like landlords. So biased. Yeah.
You don't. Yeah. Okay. All right. Thanks, Grant. I appreciate it. Good job. All right. So the common law approach, first off, I think it grants exactly right, lead to a breach of the peace, violence, right? Imagine that you come home and then you see a locksmith at your front door with a landlord, and they're replacing your locks, or they put a padlock on the door, right? You know those huge, those locks that you can't even open up. You might freak out and say, "What the hell?" And then it could very well lead to violence. You might call the cops, and the cops are like, "Oh, I don't care. He's a landlord. He can lock you out." And then all your stuff's in there, right? Your belongings, your valuables. You can't even get in there to get your stuff unless you pay the rent. And if you can't pay the rent, he might sell your stuff to offset the balance that's due. All right, so you can imagine that can create some hostility. But there's an even bigger problem in the actual violence. The landlord may be wrong. Maybe there's a dispute about what the lease actually requires. Landlord says, tenant breached. Tenant says, I didn't breach. Usually in our society, when you have a conflict involving a question of law, you ask a judge to resolve it. And that's sort of a neutral, peaceful process. But with self-help, you can't do that. Now, perhaps self-help was justified at common law because it took a lot of time to eject someone, right? It took a lot of time to actually forcibly remove someone from an apartment. So the law said, you know what? Don't waste your time going to the courts. Just take it into your own hands. All right. Everyone get what the common law rule is. Surprise, surprise, the common law rule is no longer the rule, but that was the common law rule. Yeah, Zach, go ahead.
I see the common law rule from the case we got to start with today. And they talk about the modern trend, and I don't want to get too.
We'll get there later. We'll get there later, I promise. If I don't, you can ask me later, I promise. Okay, very good. All right. Okay, Harrison, you here?
Yes, I'm here.
All right. You want to give me the facts in our first case, Berg v. Wiley?
Yes.
Little Spider-Man case.
So the defendant was Wiley. He had leased a building to the plaintiff, Berg. And so Berg was...
Well, the lease was actually not to Kathleen Berg. Who was the lease to?
It was to her brother.
Correct.
So
Good.
it was to Philip Berg. And he ended up then giving the interest to his sister.
Well, what do you call that when you say giving interest? What did he actually do? What was the legal term?
Conveyed his interest, or
be more precise. There are two ways to convey a lease.
Gave interest in fee simple.
No, absolutely not fee simple. No. What was it say? Harrison, what are the two types of ways to convey a lease?
I'm sorry. Assignment.
Yeah, that's it. That's right. Assignment. All right, go ahead.
Yeah. Sorry. So he gave an assignment to his sister. In that lease, it said that he had to give approval to modifications
Good.
to the building.
Good.
And if they didn't, if he didn't give approval, he had a right to reentry.
Good.
Once he gave it to his sister ended up making modifications. And he basically started to take possession. And so after like the 2 weeks, so she waited 2 weeks, and then there was a dispute as well to whether or not during those 2 weeks, at the end of the 2 weeks, she finally closed the restaurant for remodeling after the end of the 2 week period.
Good.
And so then there was, I'm going to use the word sketchy. It's kind of like
Real sketchy, mad sketch, real sketch. Yeah, go ahead.
Yeah. He was hanging out around the restaurant.
Who does that?
Ultimately, I'm sorry, what was that?
Who does that?
Yeah, no, it's a weird, it seems kind of weird. It makes me not trust the landlord.
No.
And he ultimately ended up changing the locks because he claimed that he was advised to by his attorney. And he ultimately ended up doing it because he claimed that he saw Berg and her friends removing panels from a wall.
Okay, excellent.
And so he thought they were ruining the restaurant.
Okay, excellent. Thank you so much. All right. Very good. So look, we have this case. This is it's a weird case because the facts are somewhat in dispute. But we do know some things, right? There was a lease, 5-year lease between Wiley and Philip Berg, right? One of the terms of the lease says if the tenant fails to meet the conditions of this lease, the landlord has the right to re-enter and retake possession. Remember the future interest of the right of entry? That's a very specific term, right? When you can re-enter things, you can come in and take possession of the property. And a common law, that meant basically self-help. You didn't have to get permission. You could just walk right in. You could retake the premise. Okay? It was a 5-year lease. About a year into the lease, Philip assigns the lease to his sister, Kathleen. And Wiley consented because you can't have an assignment without consent. Kathleen opened a restaurant, which operated for about 2 years, but it maybe wasn't the cleanest restaurant. There were a number of health code violations that the county or the state found. Now, what am I up to? That was Harrison. Marissa, you here?
I'm here.
Marissa, let me ask you a question, right? The landlord sent a letter making demands, and you have to make these changes within 2 weeks, or else I'm going to retake the premise. Was she required to make those changes? In other words, can the landlord impose, new conditions that were never before decided, in the middle of the lease?
I'm not sure.
You want to say no, but you want to say yes, right?
Yeah.
You want to say the landlord can do whatever he wants, right?
No.
But why are you unsure, though? I think it's actually helpful to articulate this.
I want to say no because that makes no sense. She never agreed to this in the first place, and now all of a sudden it's like surprise. But then at the same time, I want to say yes because she's kind of agreed to enter this relationship with.
Right. So, Marissa, let me ask you a follow-up. The lease says that the tenant agrees to operate the restaurant in a lawful and prudent manner. Mm-hmm. Could perhaps the request from the landlord fit into that category of the lease, that if she has all these health code violations, she needs to make these repairs to stay lawful?
Yes, that's what I was thinking of when I read it, because having all these health code violations, it could be at risk of shutting down.
Oh yeah.
And how she's not making income, he's not going to make. She might not be able to pay the bills, and then
Yeah. So just one more question, Marissa. The timing of this, he basically gave her 2 weeks, which was more or less the same amount of time the health department gave her, right? So maybe he was basically saying, you better make these health code changes or else I'm going to evict you. Is that kind of what was going on?
Yes, but it also mentions in the case that they already had like problems between the two of them. So it could be also viewed as him just trying to use an excuse to evict her.
Right. So thank you, Marissa. We don't know what was actually going on here, right? Perhaps the landlord was simply saying, you have these health code violations. You're required to operate in a lawful manner. So if you don't make these health code changes, we'll shut you down. Now, it isn't clear if the things a lawyer asked for were the exact same things the health department asked for. They might be similar, but they might be different. As a general matter, landlords cannot impose random requirements on tenants. Now, I think Grant says he doesn't like landlords. They do it all the time, right? All the time. She's putting his hands up, right? All the time, landlords actually do crap you never agreed to. All the time. Right? All the time, no matter where you live, it happens. But most leases have language in it that is open enough to support these sorts of requests, because landlords aren't stupid. They know that things will come up that they have to ask the tenant to do. But at least in the abstract, asking her to make changes to come into health code compliance doesn't seem unreasonable. And the fact that he gave her 2 weeks to do it overlap with the Department of Health's timeline. So again, that doesn't seem unreasonable. And usually, how this works is when you get a health code violation, they put that right up in the front door, right? They put like a sticker or like a sign in the front door. You've seen these before, right? You don't go to those restaurants anymore, but it's like public notice. It's not like a private deal. It's like here, you have to fix this, this, and this. When you see one of those on the storefront, you're in trouble. Okay, but then things get really weird, right? After the letter comes in from the lawyer in the health department, Kathleen doesn't shut down right away. She has 2 weeks, and as far as we can tell, she keeps operating her business like normal. Now, at this point, the landlord's like, okay, I know what's going to happen here. She's just going to shut down and ghost after 2 weeks, right? She's going to disappear. So then we get to this magical day of Friday, July 13th. And a lot of things happen that day. Who's next? Elena, are you here?
Yes.
All right, Elena, what went down on Friday the 13th? If it was ever an unlucky day, this was it. All right, what went down on Friday the 13th?
Well, on Friday the 13th, it was exactly 2 weeks after it was the day of the 2-week deadline that Berg was given. So she dismissed her employees, closed the restaurant, put a sign that says closed for remodeling, and then she was in the evening inside the restaurant with a few of her friends. Wiley was peering into the window in the evening, and then he was he was pounding on the back door to demand that she let him in. They had to call the sheriff. So Berg with her friends, they were tearing off the something from the walls, and Wiley also alleged the destruction of property or something. So basically, the dispute here, I guess, was that what was going to happen at the end of the 2 weeks. Is she going to vacate the premises, or is she going to do the remodeling and just close the place down for that purpose?
Yeah, excellent. Thank you very much. So, look, we've all seen this before, right? Where a restaurant says close for remodeling and then never reopen, right? We've all seen this before. There was a diner, it was right on 59. I can't remember the name of it. What the hell is it called? Oh, there was a 59 diner. I can't remember what it's called. But anyway, there was a diner on 59 right by Halal Guys, and it shut down like 5 years ago. It never reopened. What was that, Zach? What was it called?
It was called 59 Diner. It shut down like on a Tuesday afternoon, and people were waiting to eat, and they never opened back up.
You remember that, right? Yeah. Yeah, it was good. I went there a couple
I
times.
heard good things about it.
Yeah, no, I mean, I went there a few times. It was fine. But anyway, it randomly shut down in the middle of the week, and they put a sign to remodeling, right? And never reopened. So God knows, who knows what happened, right? But restaurants very often don't make money. It's a very hard business. And you guys have ever done restaurants, it's not an easy business. Restaurants don't always stay around for long. And the landlord probably presumed, maybe rationally presumed, that this woman was about to ghost him, right? Just disappear, shut down the business. So then it gets weird though, right? I would love a picture of what this place looks like. This guy's like Spider-Man, right? He's hanging off the awning, looking into the restaurant. It's like almost like a cartoon, right? I don't know how this even works, but maybe he was maybe he was a gymnast or something. I don't know, right? So he's hanging off the awning, peering into the restaurant, and he apparently sees Kathleen and her friends ripping siding off the wall. I mean, I guess, right? I mean, maybe they were doing repairs to try and fix the place up by putting siding, or maybe they were trying to steal everything that wasn't bolted down. We don't know. The landlord brings in a blacksmith. I keep saying blacksmith, a locksmith, to try to change the locks and lock her out. Then things get very testy, right? Kathleen calls the sheriff and says, this guy is hanging off the freaking ceiling and he's trying to change my locks. And then the landlord calls the police. So you can imagine, right? You have the sheriff in the one hand and you have the police in the other hand. And they're like, what the hell are we doing here, right? Why are we even here? And so the parties agree to maintain the status quo. As they say, we're just going to leave things as they are for the remainder of the weekend, let things cool off, and you guys talk to your lawyers, right? We're not going to have anyone changing. And that's often the police they're going to do. They can't resolve this dispute. That's not their job. All right. So then Wiley goes to his attorney, right? Steph, you here?
Yes, I'm here.
What kind of advice does the attorney give to Wiley?
The attorney's like, change the locks.
Yeah, was that good advice?
No.
No, that was
It's
really,
basically a form of self-help thing.
yeah, that was actually quite bad advice. Now, Steph, was that like advice that was consistent with the law at the time?
So I think it was consistent with common law if they were legally entitled to possession, and the landlord used a peaceable form of entry.
Okay.
They said this was forcible.
Okay, let me just ask a follow-up. So at the time, did Minnesota allow self-help? Before
I
this?
believe they did.
Okay, and what are the two circumstances in which self-help was permissible?
The landlord had to be legally entitled to that possession, like if a holdover, for example.
Mhm.
And the landlord had to use a peaceable means of entry.
Okay, so again, Steph, you're the lawyer for Mr. Wiley, right?
Mm-hmm.
Are those two factors satisfied here?
No.
What? Not what the court said. If you were just advising him, right?
Oh. Well,
What would you think?
the 2 weeks was up, so that one
Yeah.
was met. And I mean, I don't know if that Spider-Man move was forcible. What they putting a lock on it's not necessarily violent. It's
No, and he did it when she wasn't there. Isn't that peaceable?
Yeah, it's not illegal.
Is there any way to actually lock someone out without being mean? Like, is it even possible?
I mean, there's no way to do it without pissing someone off, I don't think.
Okay. All right. Thanks so much, Steph. All right. So, look, I often ask this question, right? Would a lawyer who gives certain advice be liable for malpractice, right? We did this with California last week, where California changes the common law every 5 seconds. I don't know that this lawyer gave bad advice, right? It was probably poor advice because it wasn't prudent, right? There was nothing they could have done, but I don't think it was malpractice. Because at the time, you could engage in self-help if two things were present, right? First, you have the legal right to retake the property. In this case, she breached, right? She failed to live up to health code standards and she just disappeared. I think that was enough. It's unclear if she actually abandoned the property, but you don't need to abandon in order to retake the premise. And the second factor is, was this peaceable? Now, look, I think what the court ultimately says is nothing is peaceable, right? Which is, you know where they're headed. But in the abstract, this seems to be among the more peaceful ways of doing it. He didn't go in there and, pick her up and throw her out the door. He waited till she wasn't there. He waited for the weekend until the police said, wait till the weekend. He waited for the weekend. And he went there and changed the locks quietly. Right? If there is a form of self-help that's permissible under law, this is it. Right? This is going to be pretty. There was no actual violence. There's no threat of violence. Now, if she was there, it might be a different story, right? But she wasn't there. This seems to have been, at least at common law, an acceptable use of common law self-help force. Okay? Yet the court holds that this self-help was not permissible. We'll get to the modern rule in a few minutes. Hey, Derek, I know you're here. Derek, why does the court hold that this exercise of self-help was not reasonable? I'm sorry about that. Derek, let me ask you a question. Could you think of a way to actually a way to use self-help that's peaceable? Like, could you just in your head, what would that look like? A form of peaceable self-help. How would that go down? Yeah, thanks, Derek. So I think there's kind of a dilemma here, right? What the court basically says here is that there's no way of peacefully evicting someone, self-help. It can't be done. Well, they don't quite say that, but I don't know any other way to read the court's opinion. If this is not peaceful, then nothing is. And maybe that's the answer, right? Maybe you can never use self-help in a peaceful fashion. Maybe that's the answer, right? But I think the court hints that way. I had an uncle who lived in New York, and he had basically an aide who lived with him for many years, just taking care of him. And then he died, and then she refused to leave. And she claimed that, my uncle gave her the property. There was no evidence. She was lying. It wasn't even remotely close to being true. He had a will and everything. But she wouldn't leave. And my uncle, my uncle's son, said to me, "Oh, Josh, you're a property lawyer, right?" I'm like, not really. I just play one on TV, Zoom. But he said, what if we just lock her out, right? And we just change the locks. I'm like, oh my God, don't do that. Absolutely worst thing in the world you can do. Because they were just going to call a locksmith then when she wasn't home. And I was like, don't do that. So what I actually told him was like, pay her to leave. Because in New York, the process is so messed up, it could take years to get her out. I was like, just give her money to leave. And that's what they did. They just paid her and she left. Like they gave her a few $1,000s. She just disappeared. Often, when you're a landlord and you have a tenant who won't leave, you have to, at least in New York, I can't say everywhere else, but at least in New York, you have to basically pay them to leave. Zach, go ahead.
Was it a rent controlled apartment?
No, it wasn't rent controlled, but she was living rent free. She's even better than rent controlled. No, she was living with my uncle, and she was like his aide, and she took care of him and made him meals and stuff. And I don't know how the arrangement began, but she was there for a year, and she just refused to leave after he died. It's one thing. It's like, well, he's dead. What are you here for, right? We need to sell the apartment now. That's New York. We'll get to New York in a bit. All right. Yeah, Derek, go ahead. Yeah, so you close read. It does say that, but you can be liable for damages, right? That's the rub. Even where self-help is permissible, you can still be sued for a tort. So it's very risky to do that. That was always a dilemma, right? Even if you engage in self-help was permissible, a court can come back later and assess liability. And in some jurisdictions, they pay treble damages for a wrongful eviction, which is very expensive. Very expensive. What is that, Marissa? My boyfriend tried buying a house and the original homeowner wouldn't leave. When he told me, I said, please stop bringing my property cases to life. You're going to see this everywhere. This is going to be like the class that never leaves you. I'll be haunting you for the rest of your lives. Like, oh, remember Blackman said this? What hell? It'll be haunting you forever. All right. So the court here holds that, let me summarize the holding for a bit. A common law you could retake if there was a legal right to retake. It was peaceable. But the law discourages taking it into your own hands. The law prefers instead summary procedure. Okay? Samantha, you here?
Yes.
Samantha, what is summary procedure? What are they referring to here?
That is a good question.
Did you do the reading?
Yes. I guess I did not pay attention to that summary procedure part.
John?
Yes, sir, I'm here. So summary procedure, it's just kind of a streamlined process to the courts to, I guess they wanted to make evictions easier and more efficient.
Okay. But how long did it take in Minnesota?
In Minnesota, was that the 14-week or the 14 days? Is that the period?
Even less. It's even less.
Was it 3 days?
Yeah, 3 to 10 days. Exactly. Thank you. Why is self-help unnecessary if you can do the summary procedure, John?
Why is self-help unnecessary?
Yeah.
Because the court is essentially taking the dispute out of it, and they're looking at the facts and determining what's going to happen.
Good.
Rather than letting the landlord have free reign as to.
Okay, excellent.
Taking you out.
Yeah, thanks, John. Very good. All right. Most states have adopted these things called summary procedures. I'll get to the Texas one a little bit after we finish the case, which are sort of like super expedited proceedings to evict, where the landlord goes to a court, and usually in a matter of days, perhaps weeks, but usually pretty quick, you can get a judgment from a court to evict someone. Okay? And when you have a judgment from a court to evict someone, it's not the case that the landlord's changing the locks. It's usually the case that the sheriff comes by and puts a padlock on the door, right? And you might say, well, what's the difference, Josh, between a sheriff putting a padlock on the door and the landlord changing the locks? Well, look, a sheriff is a respected law enforcement, well, it's supposed to be, right? But they're respected, right? And usually you don't engage in violence against a sheriff because they're under order of court. And people respect it when they're under a court order. They're not just acting on their own. But more importantly, when you have a court order, a judge has actually verified that, yes, in fact, you breached, right? Yes, in fact, there's a default to the lease. And therefore, reentry is permissible. Any questions? All right, Samantha, let's go. Oh, Derek, go ahead. Sure, I'm happy to. Right, there's a note on this in the book afterwards, and it's not an obvious answer, right? It's almost counterintuitive. Like, how could summary procedures possibly be bad for tenants? And the book explains, I think, in not what you'd expect. When you get self-help evicted, there's no record, right? You get tossed out and then you move on with your life. When you get evicted through the summary procedure through the courts, there's a record. Everyone has a credit score, credit history. And if you have an eviction on your credit history, it's going to be very difficult for you to get a lease in the future. So the book explains that in some regards, the summary procedure may cause far more lasting damage to to a person's credit history than the sort of self-help lock them out. Derek, is that what you were getting at?
I think I was looking at it more from like the.
I'm sorry, I thought you were talking about the other financial aspect. Yeah, I can talk about that as well. Most people who go to, and Marissa and Zach, I see your hands up. I'll get to you in a minute. Most people who go to these sorts of landlord-tenant courts are not represented. The landlord has an attorney, but the what do you call it? The tenant does not. We actually have a clinic here at school that does landlord-tenant law. So this is something that interests you. Definitely, take a look at it for your summer, for your second year of law school. And generally, when a person has a lawyer, they get better outcomes without a lawyer. So more often than not, the tenant shows up at the hearing. It's a 5-minute hearing, and it's like, okay, did you pay the rent? No. Is the lease breached? Yes. Okay, eviction, right? There's a process to appeal, but again, most people don't have the means to do that. All right, so the summary procedure is done quickly, but it often takes the landlord say so. Okay. Marissa, was your hand up a minute ago?
It was, but you answered it.
Oh, good. Love when that happens. Okay, Zach, go ahead.
What is your sense of how what we're going through now will impact these summary proceedings and these eviction?
What do you mean now? There are a lot of things going through now.
With eviction moratoriums and the courts being less excited, for lack of a better term, about evicting people, do you sense that that's going to create some lasting change, or do you sense there will be a day down the road where this just becomes a footnote and we get back to what was going on before?
All right. Well, it's a live issue now, so it's always hard to talk about live issues. And currently in the state of Texas, there is no eviction moratorium. The Texas Supreme Court has said there isn't one. So not all the justices of the peace have gotten the memo yet. In fact, some JPs are ignoring that, but we don't have one in Texas at the moment. For some time, there was one. I think it was unconstitutional in the federal level. It's funny, we have a clinic to help keep people in their apartments. I'm usually on the other side. I don't think the federal government has the power to mandate protection from evictions. You'll take common law in the spring or the fall, you'll see why. But currently in Texas, there isn't one. Even where there was a eviction moratorium in place, it didn't excuse the payment of back rent. Right, so people may be able to stay in their apartments for some extra months, but that doesn't relieve them from the obligation to pay rent. And credit histories we burn forever. This is the point I think Derek was asking about a minute ago as well. If you go through this process and you have a judgment against you that you failed to pay rent, it will become very difficult to obtain a new apartment, a new lease. I think that will be a lasting impact. But I don't think that we'll see a radical change in landlord-tenant law.
Okay. Yeah, and like I said, it's a live issue. It's kind of just what you sense is coming.
I think Texas courts there's no longer a moratorium. I mean, the pandemic is, God willing, almost over. I think people are going to have to start paying the rent. I don't think. I mean, the federal one, this is on very shaky ground. Several courts have declared it unlawful, but it was in effect for nearly a year. Thanks. All right, I want to go back to Samantha. Samantha, does the court stick with the common law rule here?
No, they end up adopting the modern rule.
Okay, what's the modern rule?
Basically, the lessor must exercise judicial remedies to retake the property. They cannot go through self-help.
Okay, excellent. They cannot go through self-help. Is self-help ever permissible with the modern rule?
No, they are trying to steer away from it, so they kind of don't want to look at it anymore.
Okay, very good. Thank you, Samantha. All right. So the court here, again, this is a case from the 1970s, the late 70s. The court here adopts the modern rule, and almost every state's adopted some form of the modern rule, where either self-help is never permissible, or self-help is probably only permissible in a very small set of circumstances that are very unlikely to happen. So it's true, some states still permit self-help in theory, but in fact, it's not a good idea. Yeah, if I were you in New York, and I would not try to use self-help because you're going to go to jail, and it's not going to go very well. Okay. The primary reason why self-help is abandoned is because of these summary procedures, which makes it very easy to evict someone. You don't have to go to change the locks. In a couple of weeks, you can get them at the door. Now, this guy, changed the locks in 5 minutes. That's really quick, but a couple of weeks is not that bad. Okay. Questions? Azrael, go ahead.
So how does self-help relate to things like storage units or repossession of cars and stuff like that?
That's a good question. So, I mean, with storage units, it's not really residential. So I think it's perhaps a different standard. It's a lease to be sure, but you're not living there. If you're living in your storage unit, you're in trouble. For cars, again, it's not residential. Repossessing property is a lot easier because you don't live there. There's nothing to change. So you hear stories where a guy has his car jacked from his driveway, right? They just take it away. That does happen. But it's kind of a different story because you're not living there. Thanks. What else? Yeah, go ahead, Bradley. Classroom, gotcha.
So I just have a quick question. What kind of would happen after, like in this case, if the landlord uses self-help, but obviously they're not entitled to use self-help, and the tenant either abandons or stays there, is he just out for that rent? Does he just lose it, or?
Well, if you don't move to evict, well, let me put it this way. First, if the landlord wrongfully evicts, the tenant can sue for damages. And it might actually be able to sue for treble damages because it's a wrongful eviction. The other element is if the landlord wrongfully evicts the tenant, right? That doesn't relieve the obligation to pay rent, right? So to pay rent. In this case, it's not clear that Miss Berg ever stopped paying her rent, though, right? That there are different reasons to evict someone, so the rent still going to be due, even if you wrongfully evicted someone. But you might have damages to offset the rent. Okay, good questions. Yes, Zach, go ahead.
I was kind of on the same line as Azrael, and Note 5 talks about people that live in shelters and quote unquote transitional housing.
Mm-hmm.
What about people that live in their car?
That's a good question. So
does this rule apply to real property that can't move, or
usually it's for a lease for real property? Yeah, usually it's a lease for real property. I'll be honest, Zach, I've never thought about repoing a car where that person lives in, like possession of a car a person lives in. I never thought about that. I don't know. Not sure. All right. I don't know. It's a property 2 question. I'm not sure. I teach property 2. I've never thought about that question, so I don't think that's in there. All right. Other questions? Yeah, right. Other questions on what do you guys, when you're in person, you can't throw emojis at me. What you going to do to express emotions? It's going to be very, very strange. You have to go back to actually facial expressions. Let's go back to the case. Any questions on the case? All right. In Texas, we have a summary procedure. And the upshot is you can usually evict someone in about 20 to 23 days. That's usually how long it takes, 20 to 23 days. All right. Here's the general process. The first step is to get notice to vacate, right? A notice to vacate. The purpose of the notice is to give some sort of warning that something's up, right? In this case, in Berg, there was no warning. The guy just sort of came and changed the locks, right? There was no heads up, right, that this was going to happen. Now, again, they wrote this letter saying, if you don't do this in 2 weeks, we might reclaim premise. That's not the same thing as saying, I'm going to evict you, right? Landlords give lots of demands that are completely empty, right? You have to actually give a notice that you're going to retake the premise on a certain date. Notice to vacate. Okay. Now, the notice to vacate may alleviate the problems. Like maybe the tenant thought, oh, I thought I paid rent, and then maybe the check got lost in the mail. You know, stuff happens. Okay, so you give the notice, and the 3-day period after that is to give time to cure, because maybe the tenant's like, oh crap, and she finds the rent, and everything's okay. So 3 days after you give notice, you have to serve the citation, right? Which usually means you get the sheriff involved, where the sheriff gives a formal citation to the tenant, right? And it usually takes about 8 to 10 days. So after about 2 weeks, you finally get a hearing, right, before a court. And that hearing might take 5 minutes. It's for a justice of the peace. It's a pretty quick proceeding. And the question is there a lease? Yes. Did you fail to pay rent? Yes. Are you in breach? Yes. Do you have any defenses? No. Okay. Then eviction, right? At that point, there's a chance to appeal, and there's a 5-day period to appeal. Finally, the constable has to come and put a notice to vacate, right? 24-hour notice. So again, it's not violent. They give a full day to think about it. So finally, after 24 hours, the constable can put a padlock and lock up the premise. From start to finish, it's about 20 to 23 days, which is pretty quick. So we'll look at the other jurisdictions. That's pretty quick. In DC, it's almost 100 days. In Massachusetts, it might be 2 years. New York might be 3 to 6 months to evict. What complicated the case I had with my uncle's caretaker is that there was no lease. She was just living there, and actually proving what her arrangement was would have been very difficult because there was nothing in writing. Okay. Questions on summary proceedings? Anything? No? Okay. All right. Again, we have a clinic on this issue. If there's something you're interested in, definitely check it out. All right. Let's do this second case, and actually our last case. This is a fun case. I like this one because the plaintiff was a law student, and the lesson is don't mess with a law student who's a lot of time on his hands. I think that's the moral of the story. Matt, are you here?
Yes, I am.
Matt, all right. You want to give me the facts, please, in Sommer versus Kridel?
Yeah, so like you said, the defendant is a law student, and the plaintiff is the landowner or the leaser for this property. And so the defendant signed a 2-year lease with a 6-week concession for the first month's rent. Then he had engagement, and he broke that off.
Oh no!
And so
poor guy.
Part of the deal was that their parents were going to assume responsibility for the rent after they were married. So when the engagement broke off, the rent was kind of out the window.
Oh no!
And so after that, He said that he can't pay the rent, but he surrenders all the rights. And he said, if I had a key, I would return it to you. But he doesn't have even a key.
Did he ever actually even step foot on the property?
No.
No.
I don't think so. I mean, he might have seen it, but he didn't go to live there, excuse me. And so he sent that letter saying that he couldn't take over the rent, and then the plaintiff, the landowner, didn't reply, and the apartment went unlived for the rest of the time, I think, for a year. And so, yeah, and then he started jumping again, the landowner did.
Okay, very good.
Yeah.
Okay, thank you. All right, so this is a case where the tenant was in a tough spot, right? He was engaged to be married, right? His in-laws were going to pay the rent, sweet deal. He was going to go to law school, become a big fancy attorney, and the engagement broke off, right? So this wasn't like the case from Colorado, the marriage of Graham, where the flight attendant wife puts her husband through grad school. This one, they didn't even make it to the wedding, right? Maybe maybe the woman she cut her losses short. It's like, who wants to be married to a law student? Sorry, I see a couple of you laughing. It's not always pleasant, but whatever reason the engagement broke. Yeah, Zach, please don't. Go ahead. Fine, go. What?
You said last week half of us were going to get divorced.
It's true.
So she just got ahead of the curve.
She cut her losses short. She's like, screw that. I'm not going to wait to get divorced. I won't get married in the first place. And then Emily says, who's this lawsuit with a lot of time on his hands? Well, I'll tell you, one who's not in a relationship, who got broken up with. He had some extra time on his hands, I suppose. This was his relationship, from Oregon or whatever. All right. So the question in this case is about the duty to mitigate, right? I'm sure you're studying contracts that there's a general duty to mitigate. If there's a widget and there's a breach of contract, there's a duty to sell the widget to someone else to try to lower your damages. Historically, though, in common law, there was not a duty to mitigate damages, right? If the landlord wanted to, he could keep the apartment empty for the entire term of the lease and then collect damages for the entire lease. Now, Simran, do you hear? Simran? No. Bennett?
Yes, sir.
Bennett, why would the landlord keep it empty? Why wouldn't you want to rent it out? What could possibly be the justification there? Why would you not want to rent out an apartment?
Because if the lessee was under contract to fulfill his 2-year lease, then he could just sue him for the money that he did not pay. There'd be no reason for him to.
Wouldn't it be easier? But wouldn't it be easier to collect rent from an actual tenant than to try and go after this poor lawsuit who has no money?
I would say usually that would be easier, and in this case, it would have been easier since someone was willing and able to move into that apartment unit. But most of the times, I feel like it would not be easier to go out there and find.
Yeah, I teach this kid. I was like, what was he thinking? I mean, I suppose maybe having an empty apartment is easier. There's no noise. There's no tenant issues. But I mean, he knew this guy was a law student, right? He knew he was broke because the guy couldn't even pay his rent for month number 1. Why wouldn't he just move on with his life and rent it out however many months later and just sue for whatever, couple months I was back paid? Again, where's Grant? He doesn't like landlords, right? Landlords often do things that are not very nice, and that's part of their job. So this landlord is a bit of a jerk, it seems to me. Right? Even if there's no legal duty to mitigate, a rational business person would rent out the unit to try and get rent, because a guaranteed rent is a lot easier to collect than going after litigation. Grant, right, just want people to own their homes. That's not always possible. Not everyone can own a house. It's kind of expensive. Okay. But in any event, he basically let the unit sit empty, and he ran up, thousands of dollars in damages. And then he sued to recover the back rent, basically from the day the lease began until the day the unit was re-rented for almost $6,000. The trial court ruled for the landlord. I'm sorry, the other case. There were two cases. That's the one with the other one, right? In one case, Kridel, the trial court ruled for the tenant. The other one, the trial court ruled for the landlord. We have a New Jersey case here. So what's New Jersey going to do? Reverse the common law 100% of the time. New Jersey gets rid of the common law rule. All right. So, Catherine, are you here?
Yes. Okay.
All right, Catherine, walk me through the majority opinion, please.
So what they say is that the majority, the landlord is under no duty to mitigate any damages caused by a defaulting tenant.
Okay, that was the common law rule. Did New Jersey stick to the common law rule?
No.
Of course not. What did New Jersey do?
So New Jersey said that they do have a duty to mitigate damages, and like doing so, making reasonable effort to re-let the premises, while like seeking also to recover rent. So just like making some effort to rent out the property.
Okay, Catherine. And who has the burden to show that reasonable efforts were made?
I think the tenant.
Well, generally, when you allege that someone breached a duty, who bears the burden of showing there's a breach? Right? If I sue you saying Catherine breached the duty, right, a duty to mitigate, who has the burden to show that you breached the duty?
You do.
Me, Josh, right? I have the duty. But in this case, the tenant says the landlord breached the duty to mitigate. Who has the burden in this case?
I guess the landlord
Yeah.
has a duty to show that they tried to make some effort to mitigate.
Excellent. Very good. Perfect. Yeah. The landlord has a duty. So New Jersey sort of inverted the usual rule. Generally, when you assert that someone violated a duty, the plaintiff, the person making the assertion, has that duty to make the claim. But here, it's a landlord. The landlord must show that he used reasonable diligence to re-let the apartment. So New Jersey court really sort of went off on their own here. Okay. Questions? This is now the majority rule. And I think in 40-something states, including Texas, the landlords have a duty to mitigate. It's also a good idea, right? It's very hard to tell a court, someone wants to rent the apartment, but I just want to let it sit empty. No one likes having apartments sit empty. Okay. Any questions? Yes, Matthew, go ahead. Are you in the classroom? 1 second. You think I would know by now, but there you go.
So with this majority rule, does the burden still fall on the landlord in all the states that adopted it?
I'm not sure.
Okay.
I'm not sure. I mean, to think about it for a minute, Onya, I'll get to you in a second. Right. The question is, did the landlord take reasonable efforts to re-let the apartment? How would the tenant possibly know which customers came by to possibly rent the apartment, right? The only person who would know that would be the landlord. So I think it does make some sense with the burden on the landlord here. But, I'm not sure for all states. I really don't know the answer. Onya, go ahead.
So I had two questions. My first one is, in the case presented kind of factors in determining whether or not the landlord did in fact take those steps to mitigate the cost for the apartment. However, a lot of the factors that they mentioned requires them spending kind of like a lot of money to go through this process of finding someone to sell the apartment. And I'm just kind of confused on why, or I guess kind of what's the reasonable line in terms of your landlord. Where can you stop to show, or what are courts normally saying, like the stopping point to show that, okay, at this point, he's shown his burden of proof, because they were talking about hiring an agency and going to the newspapers and doing all this stuff, and I'm just like, that just seems really costly at some point.
Yeah, I mean, look, it's very easy to take the tenant's perspective, but also the landlord's perspective as well. There are costs involved. And the courts are imposing an indeterminate number of costs. I think if I were a lawyer in New Jersey, much like a lawyer in California, I would say, do not bank on collecting back rent. That if a person vacates an apartment or they vacate the unit, try as hard as you can to re-rent it, because you're not getting the rent from the person, right? So it's basically New Jersey saying, if you can't pay your rent, just leave and you'll get a free pass, right? You may owe whatever rent for a few months, but you won't owe the entire lease. That's how I see it. Okay. What else? Yeah, Bennett, go ahead. Bennett, you there? Disappeared.
Sorry, can you hear me now?
Good.
Is the original tenant who breached the contract, is he able to provide someone who will take his place on the lease instead?
Well, that's a good question. I mean, if the student had like a classmate or someone to take over the lease, that's fine. There could be an assignment or sublease or an entirely new lease. If the landlord refuses to take the friend, that actually goes against mitigation. Like, look, you had a tenant right here, you didn't want him. So that might be one way to mitigate it. Clear, I can't do it, my friend can. Of course, you have to find someone willing to do it.
Okay.
All right. Other questions? All right. That's all I have. We're a little bit early. Let me put the minute poll up. Oh, Grant, go ahead.
Since we got a little extra time, it's maybe not quite on topic, but I was wondering if you could tell us a little about what happened in Hawaii with this Hawaii Housing Authority being Midkiff.
Oh, you'll do
in Sawada.
You will do that case in property too. I can happily describe it for you, but doing property too. Hawaii, as you may know, is a series of islands. There's not a lot of land. It's a pretty small state. And most of the land was owned by a few wealthy families and corporations, what you might call an oligopoly, right? Where it was a very small ownership. And it was very rare for families to actually, for a person to own their land in fee simple. They mostly were leaseholds. So the state of Hawaii came up with an idea. They would force landlords to sell their property to their tenants, right? They would force a sale. The state would use the power of eminent domain to basically seize it and transfer it from the landlords to the tenants. Landlord said this was a taking of property in violation of the Fifth Amendment Takings Clause, and the court unanimously ruled against the property owners. Not a decision I much agree with, but it's one that the court held, and I don't think it would be good law anymore, but that was the law in the 80s. That's the case.
So did the renters have to rent for a period of time, like 5 years or something like that?
I don't remember. It's a good question. I don't even know if I don't remember. Okay. What else? All right. Well, the minute poll's running. I think there are two things just to keep in mind for today. When you're approaching landlord-tenant law, always think in terms of contracts. And whatever doctrines you learn in contracts, kick in here. The second process is always use the courts. Landlords should not take the law into their own hands. They should not try and evict someone, and they should not try to, change the locks on someone. That's a very bad idea. From our second case, the lesson is mitigate, mitigate, mitigate. Always try to mitigate your damages. All right. Any other questions? All right, everybody. Have a wonderful day. I'll see you all on Wednesday. Hope if you're getting your shot, you feel okay. But take care. Zach, go ahead.
Sure. I'm still fascinated by this question I brought up about the people living in their cars.
I really have no idea, Zach. I'm not sure.
Do you, and it may seem pedantic, but I think it becomes more relevant with increasing people struggling to pay rent, homelessness on the rise, people wanting to live in an RV. What about someone who gets an RV and then doesn't pay, but they live in it?
I'm sure there's a law. I don't know the answer. I'm not sure. You're welcome to look into it and report back, but I don't know the
This is what
answer.
I'm going to look up in the summertime. Yes, I wrote it down.
All right, Zach. I'll talk to you later.
All right,
Thank you.
Thanks, sir. Have a good day.
Goodbye.